Thank you, everybody, for joining this afternoon. Welcome to our program called Tips for Drafting Family Law Judgments. And I am told a lot of people, more than 140 people signed up. So we're all very confused and excited for this program. Before we begin, a couple of housekeeping announcements. You will receive your MCLE certificates shortly after the program. Please take a moment to complete the survey. This is included with your certificate. And also Alex will share the link to the written materials, which should have been emailed to you already. And we have two very generous sponsors. The family law section is sponsored by White Zuckerman, Worstovsky, Luna, Hunt LLP, and our family wizard. First, White Zuckerman, as we all know, provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. And we have Our Family Wizard. Our Family Wizard is a secure co-parenting platform that supports divorced and separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and many more, all while thoroughly documenting their activity. For your upcoming CLE programs, we invite you to visit bhba.org or to look for email notifications you may receive. Be sure to sign up for our upcoming event program, which is our annual symposium happening on November 6th. And it's from 8:30 in the morning till 3 p.m. I know it's a long program. It's going to be very packed with a lot of fun stuff and the stuff that you want to know. You know, the e-filing is coming along on the 15th of November, and we're going to teach you all the logistics, the practicalities of how to maneuver yourself through all those changes. We have the tech panel, we have the financial panel, and we have the custody panel. And again, Alex will be sharing a link to sign up for that program. So please click on that and sign up if you haven't already. And if you have any ideas for future CLE programs, please feel free to email me or my co-chair, Kendra Thomas. I will now introduce our esteemed panelists who need no introduction. We have Judge Amy Pellman, the Assistant Supervising Judge of Family Law Division at LA Superior Court. And we have Peter Ontiveros, Family Law Court Operations Manager for LA Superior Court. And for those of you who don't know Peter, he has been with LA Superior Court since 1999, then as a family law judicial assistant since 2007, and then as a judicial operations manager since 2015. So you can trust that he knows a lot about family law. And if you have any questions, reach out to him maybe. And we have Kendra Thomas, CFLS at Thomas Law Office, who is also co-chair of the BHBA Family Law section. And we have Brian Lepak, CFLS, and he's been everywhere. He knows everybody. He knows everything. So if you have questions, maybe you can ask him.
I'm old.
Okay, so if you have any questions during the program, please feel free to post them either in the chat or Q&A. And now onto the program, Judge Pellman, if you could take it away and open our eyes to the Judgment Assistance Program.
All right, well, first I want to thank the Beverly Hills Bar for putting on this program. Everybody has just really come together and put a tremendous amount of work. And as you will see, there is an amazing amount of resources that you can take advantage of. I think we all sometimes forget to check the website when we're looking for information. There is just the court administration has just done a tremendous amount of work putting together checklists that will be very helpful to all of us, frankly. And we're very fortunate to have Peter join us today. This is I think, somewhat unprecedented, that we came up with this idea to actually have somebody from court administration on this program. And we couldn't have asked for anybody better than Peter. So thank you. So now comes my plug for the Judgment Assistance Day. So the Judgment Assistance Day was not my idea initially. We had a smaller program in Pasadena, and when I came, and Irene Mack ran it, so many of you know her, she's fantastic. And when I came back to Mosque in February, I thought, why aren't we doing it here in Stanley Mosque? And then once we kind of finalize our program, bring it out to the entire county. So another first time, I think, is I was able to get the agreement of the Beverly Hills Bar as well as LACPA to work together. And so what they are doing is providing pro bono attorneys to finalize judgments for a very particular population of self-represented litigants. So you might have noticed that we now have a program on the court so that you can actually fill out your judgments online. It's great. It's like the old Legal Solutions, essentially. This program is not for people who can do that. This program is for people who will never fill out their judgments for whatever reason. They don't have a computer. They don't speak the language. They're never going to be able to follow the instructions. And these are the cases that come back and back and back and back. And it's frustrating to the lawyers who are waiting to get their cases heard. It's frustrating to the judges who are trying to explain things to people. And it's most importantly frustrating to our community litigants who really need the help, and we are there to help them. So we have started this program. Please volunteer. They are very, very easy judgments. There is nothing complicated about it. We have a tier system. So once the judicial assistants send the electronic packet essentially to our court managers, these are also volunteers through the Beverly Hills Bar and LACPA. Those will be then sent to you as the pro bono attorney, and you can do 1, 2, 3 of the judgments. You have weeks to do them. They will then be reviewed again by the managers. Then they will be sent directly to the judge. The judge will sign it, and it's done. So it's a fairly simple process. We are not really talking about those kinds of judgments today. We're talking about your judgments more. But as I said, if you go on the website, and if you join this program, lickety split, you're going to become an expert. So please volunteer. It's a great program, and you're going to feel really good about helping people who can't help themselves. So thanks.
Thank you, Your Honor. So what we're going to do today is we're going to have a general discussion. You don't have to follow any of the materials that you've received because we're not following along with any of the materials. We're just going to have a discussion on judgment issues, not necessarily just drafting, but just related to the judgment. So if you have a question, definitely feel free to email us, and Kendra and I will try to, and Gina will try to make sure we get your questions answered. And we'll just start the process out by directing to Peter. And he's going to point out the fact that some of the stuff that's attached to you is important, but you can look at it later. But the first question I'll ask is, what documents get lodged when you submit a judgment with the court, Peter?
So when a judgment comes in, you're looking for the FL 180. I'm assuming we're doing dissolution at the moment. The notice of entry of judgment 190, declaration, default, or let's see what else. You can submit the preliminary decks of disclosure, waivers. There's a bunch of different types of documents that can come depending on the scenario. It isn't one specific set.
It also, of course, depends on what kind of judgment. Is it a default judgment, a stipulated judgment?
Right. There's a bunch of variety to what can be done. The real key is to follow up the entire checklist and make sure that you're covering all the requirements, such as service of the declarations of disclosure and anything that you need to accomplish. If it is a stip judgment, you do have 2 different lines of checklists to follow.
So the point here being that there's really no one answer, and you have to go look at the checklist that we have attached to your materials, find your scenario, go down the list, check it off to make sure you've done everything that you need to get done, and then submit your judgment once you know that checklist has been completed. Is that correct?
Correct.
Okay, so we've been all drafting judgments for a while now, and say we have a stipulated judgment and it gets submitted to the court. I'm not sure we really know what happens to that judgment once we lodge it with the court. So does it take one person to review it, 5 people to review it? What's the process for getting a judgment through the court system?
Okay, it's funny. I was in the middle of reading that answer or that notes when you asked the last question, so I lost my train. So the judgment goes through several steps. We have an intake person who will track it into an internal log in addition to our case management system. So if you ever try to bypass and send a judgment to the courtroom directly or someone you happen to know, and it misses that step, it makes it very difficult for us to find it down the road, because our tracking system is the first thing we do, is we put it into our judgment tracker, which is internal. From there, it is sorted into either courtroom document or a clerk's office document. If it's a paternity case, that has to go to the courtroom. If it's contested after a trial, that has to go to the courtroom. Everything else is going to go through us, through the clerk's office. From that stage, what we still have, it gets sorted into date order. We process the oldest ones first. Once we get to your judgment, it's going to go through a clerical review process. Hopefully by the end of the year, we want to shoot to have that done within 2 to 3 weeks of submission. We're not there just yet. And that review process will alert you if the judgment is rejected. You'll know right then and there. If there is a requirement for a default prove up, meaning the case is trying to terminate visitation rights or have it non-proton to an old date, there's a list of items that if you ask for, it has to have a judicial finding. We can't do it clerically. Then it'll get routed to the courtroom at that stage. Assuming that it doesn't have any of those, then that reviewer will send it to a courtroom. The way we do it at Mosque, all of the judges sign judgments. I think we have 31 of them. They get rotated 15 to 20 a week, and we send it and we ask them to process it within a week's time. Most of them are great about that. They'll do them within a few days. There's no guarantee. Things do happen, and sometimes it takes 2 weeks for the bench officer. When we send it to the courtrooms, it is just an ask. So the timing for that is a little slower sometimes. Once they sign it, if they sign it, they return it back to the clerk's office. A different person will receive them. Anything that was judicially rejected, they found something we missed, those we process with priority right then and there. Anything else will get mingled with all the other courtrooms, since we send them, most weeks we'll send it to 12 to 15 different departments. And then staff will, over the next 2 weeks, the way their shifts play out, they will file stamp, enter, and send them out. So it really goes from intake person to reviewer to courtroom to file stamping. And that whole process, if we're on point, it should be immediate, within 2 to 3 weeks, within 1 to 2 weeks, within 1 to 2 weeks.
since we're talking timing, how do we go about checking the status of a judgment? I know that is one of the number one questions I get from clients. How is my judgment? Where's my judgment? Where do we go to figure out where the judgment is in the process?
Okay, so there's some cues that you can follow. Once you submit it, the first thing to do is check the attorney portal to make sure that there's an event entry titled JPR. It's judgment pending review. It's spelled out. If that will let you know that we have it, that we received it. If you go to the website, we are posting our review date. So when you see on the Family Law LA Court website, the date that it indicates for judgment processing, that means the day that we're reviewing it. It doesn't mean the day that those judgments are being finalized. It's our first grab at it. So if it's before that date, you simply just need to wait until that date or that week occurs. If it's after that date, what you'd want to look for is the other documents with your package that they were entered. So if you can go to the portal and see that your appearance statement waiver form or declaration of default, if those were entered in the system and you did not receive a rejection letter, that means the judgment itself was approved by the reviewer and sent to the next phase. If you received a rejection letter, obviously it's rejected. But that's the next cue, is to look for those documents. And then we have to wait for the bench officer that next 2 weeks. So if you time it out and you go beyond 2 weeks from the date that those document entries were done, and you did not get a rejection letter left, now it's sitting in a pool waiting to be file stamped, because the rejection letters are sorted immediately and processed within a day, usually the same day.
And Peter, we don't, you don't send the judgments to the courtroom they originated in, do you?
No, it rotates amongst all courtrooms. It just goes on this weird rotation because there's dark courtrooms. We get individual requests. So however many we have, we'll go out to the next batch of departments. And then the next week, we're going to send another group, and it'll skip whoever's dark, it'll skip, and then it'll just constant rotation amongst the necessary departments to clear out what we have reviewed. And currently, it should, I guess it's worth noting, we are working overtime every weekend on reviewing. So the review capacity, or the amount of judgments that are ready for the judicial officer, currently exceeds the department capacity. So bench officers like Judge Uhas and Judge Convey, who I've known both of them for a really long time, they'll take and they'll sign 100 of them for me in a couple of days. So the timing is a little off right now. That should all be rectified by mid-November is the goal, maybe Thanksgiving week. So what I'm kind of telling you how it was and how it's going to be once we clear this hurdle that we're going through right now.
So there's some follow-up questions to what you said, Peter.
Sure.
The date on the website, that's the date that it was lodged with the court? Is that the date that's being referenced on the website?
So the date on the website.
And where exactly on the website is that located? That's the LASuperiorCourt.org website you're talking about, correct?
Yes, it goes to LASuperiorCourt.org, go under the Family Law Division. And when you get to the first page, I believe, I haven't checked since we started doing it again about a month or so ago, it should be on the right panel. But it should be right on that page. And the date reflects the date our clerical staff is reviewing them. So say we're at, well, like now, right now, I believe we are reviewing at about 5 weeks. So something that was lodged 5 weeks ago, that 5 week ago date would reflect, we're looking at what was lodged 5 weeks ago. This is what we're reviewing. So it will indicate the lodging date or the submission date, but it should tell you that we're at a review stage.
So how long approximately is it taking for judgments to get processed at this point in time?
Because of the overtime, there's a little bit of inconsistency. We've had weekends where there were over 20 staff working, clearing things out, so we get this massive boon ahead of time. But from beginning to end, we're at about an 8 to 9 week from submission to the date that we're pulling off the shelves for file stamping.
Okay, and if it's now
It's
12
also a
weeks,
workflow problem.
if it's 12 weeks, now we're thinking, okay, it's past the normal 9 weeks. What do we do at that point?
So there's two different things. One, is it with the clerical staff or is it with the courtroom? Courtrooms have their own individual systems. If it had to go to the courtroom for some reason, the judge could be waiting for a hearing. There's various reasons why it could be sitting in a courtroom. In a clerk's office, let us know. The one thing that I did find out this week is they focused on reviewing completely, and they did not do the file stamping aspect. So with weekend overtime, we get clogs in our workflow. It's not designed to have such a huge glut in one part of the process. So the file stamping is taking longer. This coming weekend, everyone is going to be dedicated to file stamping. So even though there may be a 10-week and a 12-week sitting on a shelf, if that happens to be the case right now, the goal is to have multiple days and hopefully multiple weeks cleared out at once. I believe that there are somewhere in the neighborhood of 450 to 500 that were newly signed by our bench and that are going to be addressed on Saturday.
So what do you see as common reasons for rejection? And by the way, do we need an original signature on a judgment, or can we do a DocuSign, or can we use a copy? Does it matter anymore on that?
So that's a good question. Original signatures are preferred. They're easy. But the first general order that went out, we are taking electronic signatures. DocuSign is fine. Photocopies, we are treating them as an electronic signature at the moment. So that today.
When you say at the moment, is there something you can let us know when that moment changes so that we don't screw this up and get a judgment rejected?
We're still under several general orders from the onset of the pandemic, and there's no expiration date on them. There's just the next general order. So when the next general order comes, I don't know what it's going to say. And we're going to follow whatever they tell us it says.
Will the presiding judge maybe post that on a blog somewhere?
He does.
Some associations blog.
No, notice to attorney goes out every time they update the general order. And I use that non-committal language because they can change it every time at any moment, and we have no control over that.
Okay, if you email me, we'll make sure that BHBA will post it to its members.
And also you referenced DocuSign. Is it any type of electronic signing that's
Yes.
all right and accepted? Okay.
Yes, I just mimicked what Brian said, but yes,
Okay.
if they use other services, that's fine. We don't discriminate from one service to another. They're all the same.
And do we need to submit the authentication credentials as well, or merely the signature?
Just the signature. And I'm sorry, I know Judge Pellman wants to say something too.
Sorry.
No, I was just going to say that there was a question. We're saying DISOs, but we're including parentage judgments broadly.
Great.
Thank you.
There's another question.
Well, the other question is, what are common reasons why we're getting these things rejected? What are you seeing that we're doing wrong that we should correct so that we don't get these judgments rejected?
I don't know if there's a most common. There's a lot of different reasons that things get rejected. People just overlook things. The one mistake that I do get weekly, I'll say, when it comes to default judgments with agreements, which is very common at Moss. The party that's been defaulted, they sign that final waiver of declaration of disclosure at the end. If both parties sign that document, they're declaring that they filed their preliminary declaration of disclosure. And that's almost never the case. So when they sign that, they're making an assertion that effectively requires us to reject it because it's inaccurate. That's a very common one that it looks like you've dotted all you dotted all your I's and crossed your T's, but in effect, you created a problem by processing a document that was unnecessary. If they actually just left that blank and were silent on everything, that would be acceptable. But that signature is a large number of our rejections.
Now, Peter, if somebody has a default judgment and attaches an agreement between the parties, what do you do?
So we're verifying the agreement has to be notarized. We're verifying their signature, or if it's not notarized, they would need to submit an appearance statement waiver to make a general appearance and pay fees. The notarization, one good thing about 2336 is there's no fee requirement for the respondent with that agreement if their signature is notarized. So we're verifying that. And the default requirements for matching a petition to a judgment are alleviated because there's an agreement. So they can deviate from what the petition said. But the real thing is we're just making sure that the signed information is verified in some way with the appearance statement waiver or the notary. And of course, if there's a fee issue, we want to make sure that that's resolved. Then it basically becomes a stip.
So in terms of rejection, am I going to get a judgment rejected because I haven't legally described something correctly? I know we have property descriptions that may need the legal property description. What about vehicles? Am I using a license plate? Am I using a VIN number? What guidance can you give us?
So going through the types of judgments, when you're in a courtroom, if it's a contested judgment, you follow whatever the judge says, period. If it's a stipulated judgment where both parties are agreeing, if you don't include that language, we're not verifying it. We're not verifying that the VIN number or the property language, identifying it the way however you do, if it's enforceable or not from a clerical standpoint, that's not on us, that's on you. We will review it and that'll be accepted. And the bench officer that does the judicial review, they can make that call. If it's a default, include all of the details. You should have the property description. It should match exactly what the petition says. And not just match what the petition says. If you expand on it and add, the petition just says white Ford Bronco. And you want to include the VIN if you can, if you have it. If it's a property, you want to include the legal description. If it wasn't in the petition, adding that additional information is fine. It doesn't have to be identical. You just can't give us less, but you can give us more.
Thank you.
So Peter, we normally add to judgments at the end to say this judgment may be executed in multiple counterparts, each of which shall be deemed to be an original and transmuted by fax or electronic email. Each shall constitute a whole pursuant to Rule 2.305D of the California Rules of Court. I take it the court's okay if we don't have everybody signing on one page. We have multiple pages that get signed for the judgment.
Oh yeah, that happens all the time. Yeah, that's an issue.
And then another question is this process going to change with e-filing?
So judgments are not going to be part of the initial OFS launch. You're going to still have to file your judgments in paper format. And it's worth noting, since I guess I have an audience, the requirement to file through OFS, there's documents you're going to see that are in a judgment package that are allowable through OFS. If you file them in paper form, because that's required, that's fine. You don't have to separate your default just because that is fileable through the new filing service. You can include it. You can include the various declarations. We're not breaking apart a paper judgment package to accommodate that rule. It's acceptable. It will cause too many problems if we try to make you file a package in two different formats. So just as a side note, since I'm teaching that right now.
So if a judgment gets rejected, what's the process? Does it have to go through this whole system again? Is there a way to expedite this? What should we be giving you when we resubmit the papers? Do we have to get the judgment re-signed, or can we just correct the one defective page and keep the original signatures?
So that's a great question. I'll say, if it was rejected in error, that's when I'll look at the cap. If this one was rejected in error and we made the mistake, contact the court and identify that we made the mistake, and you will get priority. If it's something that we can clearly identify as clerical error, you should not have to go through the process again. I've done that. I don't know who's on the participant list, but for several parties, attorneys, if it's your mistake, if there was a clerical, if it was rejected for a valid reason, it is going to be filed as a new judgment. It will start from the very beginning of the process.
You have to refile all of the paperwork, not just the corrected paper. Isn't that correct?
Correct. We will be sending back the entire package. You will need to resubmit the entire package. The signatures don't have to be redone again. If the error was something simple, correct the error on the pages, and that's fine. The problem you may run into when you're trying to resubmit it is if there was something stamped or we partially processed it, you don't want to send back a conformed copy of a document to be refiled as new. That you'd have to print new. And if it was conformed, we accepted it, because depending on the stage of rejection, some documents are data entered. The reviewer is going to enter the non-modifiable documents, notice of entry of judgment, the judgment itself. They're going to send to the courtroom and not file. The declarations are going to be file stamped and data entered, in part to tell you that it's moving along in the process. You don't have to send those in again, but if you do not send like a whited out conformed copy. Print a new version. And don't cross it out ever. You'd want the newest, cleanest part. But if you have a conformed copy, you don't have to send it again. It's in the system.
And Peter, isn't one of the things that is often missed are proof of disclosures in general?
That gets skipped quite a bit. Preliminary or final or the waiver. That is a common mistake at one stage or another for all types of filings. And that actually happens a lot more in STIPs than it does in the default with agreement world. Just because they want to get to their agreement so fast, they're like, we're good with everything, here we go. And they kind of jump the gun on disclosure.
So sometimes it seems like we get judgments rejected and we find out later that there was some rule in place and we're not sure of where that came from. So I think when Judge Nelson was the presiding judge, it used to be you couldn't say the court finds. And suddenly if you said the court finds and there wasn't any litigated process, your judgment got rejected. How is this happening, that there's these rules that we don't know about?
So that they're not necessarily.
That's not a rule anymore, correct? Or is it?
She was right.
Okay.
So for those of you that don't know, Judge Nelson several years ago instructed the judgment unit to not process judgments that said the court finds when it was by default or stipulation, because that's an agreement or that's a decision. It's not the court making a contested ruling and finding something. So that language was inaccurate, and she said that's inaccurate, reject it. We don't measure that now, but it is still good practice. So no, that does not get rejected for that terminology today. But today we are working under what the last supervising judge to make a definitive decision on interpreting something was Judge Lewis. He indicated that the defaults when it comes to a petition being identical to what the language of the judgment was not his interpretation. It was the judgment cannot ask for more than what the petition says. So the easiest example is, say in the petition, I'm gonna terminate spousal support for respondent and not giving anything. And then come the judgment time, they say they want to reserve. Well, the respondent is actually getting more than what they asked for. That's okay. You can move that direction where the respondent has a gain. And if anything is silent, silent means reserved to us. So if you just don't address the issue, and then on the judgment, you're like, oh, I'm going to terminate, well, no, now you're taking something away. Being silent was reserved. Terminating is more, you're asking more, that'll get rejected.
So I think we as attorneys are fine if there's these gray area rules. It's just that we would like to know what the rules are before we get the judgment rejected and processed. So as the presiding judges come up with these rules, hopefully you guys can let us know so we can let our associations know and get those rules out there so there's less rejection that happens for us.
So that one, there's short-term positions for the supervising judge. I don't believe Judge Riff is running again. So there will be a change of guard in the very, very near future. When that information comes, I can communicate it to you, the two of you.
Appreciate that.
Thank you.
Speaking
really
of
sure.
another rule that happened or that got changed was that with celebrities, oftentimes we'd have a marital settlement agreement or some kind of judgment on the side and just do a skeleton judgment saying, yeah, we got another agreement. And if it doesn't, somebody violates it, we'll then go and submit the rest of that judgment. At one point in time, that was okay. And then another time that got rejected. I don't know what the status is at the present time about having a skeleton judgment that says, we got this other deal that will pull in as a judgment if it needs to be enforced.
Okay. So now I know what you're talking about. You are going back several years when they used to have a judgment that simply referred to the MSA.
You're kind of getting a status and kind of referring that there's another judgment out there, guys. If the parties don't comply with it, then we'll submit that judgment and get it signed. It's not signed by the parties, it's signed by the attorneys, but it hasn't been signed by the court yet. If somebody doesn't comply with it, it's like a marital settlement agreement, I guess,
Right.
but it will turn it into a judgment.
So the court's still going to go through the FCCR process and make you go to judgment. It doesn't qualify as a judgment. You can have all the MSAs you want. There's nothing wrong with doing that, but it is not treated as a judgment. That was also, I think, Judge Nelson's time when she started saying it wasn't acceptable to have submit the 180 that just said refer to or the MSA and try to close out a case. They don't do that. A signed judgment by a judicial officer is required. And you can submit like a status only and reserve and use that as orders on the side, but it's not a judgment.
So if we get a status judgment only, is the court still going to follow up to say, hey, you guys didn't do custody yet, you didn't do support yet, you didn't do property division yet, even though in theory, maybe we resolved it in an MSA / judgment on the side, or do we get off the radar once the status judgment has been entered?
No, we're still going to follow up.
Okay.
What is it? CRC 5.83 requires that we follow that family-centered case resolution process and bring everything to judgment. And there's other CCP rules that you have to meet certain milestones as you go forward. And that would stay on our radar until an actual judgment with some substance to it was submitted.
Well, you reference, sorry, go ahead, please, Judge.
No, just that it's whatever home court it's assigned to, if it's a special circumstance, also it's going to be in the discretion of that judicial officer to take the FCCR off calendar.
Well, and you mentioned one judgment. How do you feel about, can there be multiple judgments? For example, okay, so we take status and we have a status only judgment. I mean, am I okay then to do like a custody judgment and then a separate property judgment? Or is there a preference that after status, there is one judgment, so to speak?
Well, I guess if the parties want to keep spending money on multiple judgments, I suppose they can, but it's not efficient for the litigants, generally speaking, or the court or the administration. So can they? I suppose they can. Should they is another question.
Yeah, so you can submit judgments on reserved issue for each issue, as Ms. Rios is asking. It is not efficient, but we won't reject for that.
And because we discussed status only judgments, I mean, how does the court feel about add-ons to the statutory requirements for a status judgment? Do you want to see the basic statutory stuff and that's it? Or I see a smile.
I think that if you're doing an add-on, you're not doing a status only judgment. And so if you look at the rules, the answer is no.
Well, there's an unpublished case involving Fletcher Jones. If you go online and look, it was involving the Kolodny firm and the Wasser firm, where there was some additional add-ons and a substantial number of additional add-ons, and they're pretty detailed. So it'll give you some idea. That particular appellate court said it's really in the discretion of the trial judge if they think it's necessary to preserve the property rights of the other one of the parties. But they also referenced the fact that if it's not in the statutory requirements, really, was it necessary? Because maybe the legislature didn't think it was necessary.
I mean, of course, I recently had a case actually where those issues were discussed, but those are the issues in 2337. If you're kind of moving outside of that, I think that's where you start to get into more of the muddy water.
Well, so for instance, one of the things they wanted was if you get remarried, then you waive the spousal privilege with regard to the new spouse, which is not in the statute. But again, trying to get these other things added in. And I think the trial court in that case didn't give that additional term. But as I would say, as an attorney, can't hurt to ask. So if you've got other things you want, ask the other side and see what they'll agree to. But whether it pays to then go litigate over it and file a motion and see if the trial judge will give you those terms, I guess it depends how wealthy your client is and how much they want to see what the trial court will do to give you some of those additional terms.
Peter, do you want to address some of the questions in the chat?
Oh.
Not Peter, Brian, I'm sorry.
Let's see.
So Peter, there is, let's backtrack for a moment, if you don't mind. You had initially given an example regarding support when we were talking about, I think it was in the context of the default judgment and the petition asking for support. The question is that if the parties agree to waive and terminate jurisdiction over support in the agreement, but it wasn't sought in the petition, will that lead to a rejection?
If there's a signed agreement? No.
Correct. It looks like we have the parties are agreeing to waive and terminate jurisdiction, which would indicate a signed agreement, but that was not, was not sought in the petition.
If there's a stipulation, they can deviate from the petition as much as they'd like. It's defaults where you can't deviate. And if you do, it has to be in favor of the respondent. And even then, there's lines, there's gradations.
There was a question also as to how do you keep financial terms of a property settlement portion of a judgment confidential, if not through a private judge?
With the court, you'd have to ask to have that portion sealed.
Good luck with that.
Yeah, we don't.
Yeah. That ain't gonna happen.
Family law is a public forum. Judgments are a public record for the most part.
So you generally have a marital settlement agreement, and then the judgment that gets drafted doesn't include all of the terms. So if you have bank accounts listed, you might say this is what one person gets, this is what another person gets. And then you may divide them, and then by the time the judgment's entered, all the judgment's going to say is that one party gets the bank accounts in their possession, and the other party gets the other bank accounts in the other party's possession, as a way of trying to then in the judgment not to reveal as much financial information as I think the tendency to be able to have some confidentiality. That'd be my. And I think you might be able to submit an MSA and then not have it in evidence, but lodge it. That's according to the Rudder Group. But I would suggest go looking at the Rudder Group on that particular issue. Before I get to some of the other questions out here, ex parte application to have judgment entered. Are we wasting the court's time with this one?
I would say mostly. Remember what the ex parte rules are. to even get before the court. So of course, there's going to be exceptions, but my wedding is coming up and I forgot. Maybe the judge is going to be nice, maybe they're not. You can't really count on it, but it probably doesn't qualify as exigent circumstances that couldn't have been avoided.
Yeah, I wouldn't count on that. I'd think the ex parte is going to get denied more likely than not. Peter, any thoughts on that?
You have to meet the minimum requirement for exigency first. That's the hurdle, regardless of the judgment itself. So yeah, that's a very, very tough one that I don't see many.
Well, if the judgment got signed but didn't get entered and there's a delay, I guess nunc pro tunc, in theory, you got married and go, can we have the judgment entered nunc pro tunc before my new marriage date? Is that a possibility? Maybe is a solution if that happens.
That's a viable remedy for sure. And keep in mind, if the judgment's in process, communicate with the courthouse, wherever it is, to find out where the timing part. We don't pick and choose when they're stamped, signed, but work with your local manager at wherever your judgments are. If you know that it's through the system and you just want to make sure it doesn't get lost, it's better to communicate with them so we can make sure it doesn't get lost and delay that extra 2 weeks that's going to possibly ruin someone's plans. We can try to avoid that. It doesn't even get priority. It's just making sure that nothing bad happens. So if you, as a first line, I would try to contact the court and figure out where it is and get their take.
Speaking of delays, your final instruction, Peter, on what to do when the submitted judgment is taking longer than expected, should we be calling our home courts and our home court department to check on judgment status? Or will that just put us into like the phone queue?
It will put you into the phone queue, but verify the stages of where it's at. Set your expectations at a realistic level. If you file a judgment, this isn't a turnaround time like an RFO. You're not getting this back within a couple of days. It is going to be when we're optimum. We're still looking at that 4 or 5 weeks from beginning to end. That's the goal. And we're several weeks beyond that at the moment. So,
in all likelihood, the home court's not going to know anything more than the attorney's going to know.
Right. Yeah. And the vast majority, at least at mosque, they're not in the courtroom. If it's a paternity action, it is. If you had a trial, it's contested, it obviously is. If you know you've had one of the default items requested or nullity, no visitation order, something like that, then it's in the courtroom. If it's not in any of those scenarios, don't call the courtroom. They don't know. We don't track the home court or inform the home court of status of judgments, especially at mosque where we're going to get between 12 to 1,500 judgments a month, depending on where we are in the year. So call, I would say call if you've met the criteria of verifying that it's not pending, it's beyond what it should be. You can call in the queue, you can ask for whoever the supervisor is over that department, the judgments, to take a look because something's wrong on our end and we do need to know that.
So is calling the home court judge not a solution because they might not even be the one processing the judgment, or would they be able to track down who is processing the judgment and help us out by calling the home court? It's taking weeks beyond the normal.
So if it's a paternity case, contested, or there's something in it that required a judicial determination, a prove up of some sort, if it has one of those components, calling the home court's appropriate. If it does not fit that criteria, they can't help you.
Are you going to get a judgment rejected if you attach a disomaster after the judge's signature and reference it in the judgment?
No. Yeah, no, that's.
But the better practice would be to include the terms within the judgment, the terms that are in the dissemester, correct?
Yes. You don't want it, not that someone's going to tear it off later down in the future or an issue to happen with the page. You really would prefer it to be throughout the judgment in front of the signature.
There was an earlier question, Peter, about default judgments, that if you submit one with a notarized agreement, you said there shouldn't be a stipend waiver of the FDD. Does this mean that the petitioner must serve an FDD before judgment? No, even though respondent hasn't served a PDD or FDD, or is there a way to waive FDDs without respondent serving any disclosures?
So it's only rejected if the preliminary declaration was never processed. And by signing the waiver, you're asserting that it was probably that they submitted a PDD. The best thing to do is to have them not sign any of that, just sign the judgment, because they're not required to do it because they're defaulted. So you already passed the hurdle you need. By signing the waiver, you're creating a new hurdle.
Peter, we also have another question here as to whether stipulated judgments for celebrities with some terms that are set forth on an unfiled further judgment on reserved issues, are those being rejected? So I think the question ultimately is, if you have a stipulated judgment which references an unfiled further judgment on reserved issues, is that going to create problems?
For rejectability?
Yes.
No. For enforceability? Probably. But for rejectability, no. If they have a judgment that addresses to an extent the necessary topics, that they have kids, support, we don't look to see if it's enforceable from a clerical standpoint. As long as they followed all the procedural requirements, all the formulaic requirements, and they hit on all of the required topics, they can make reference to other things that exist in the world, and we don't look. It doesn't affect the rejection letter. A judicial officer may have a different view, and that is one of the things I've noticed since we rotate now amongst all of the central bench officers. They don't all think exactly the same way, and there's a chance that it could be judicially rejected, although that's really rare. I mean, really rare. Less than 0.1% of them get rejected judicially, statistically speaking, in the last couple of years.
So I know that the child custody evaluation is supposed to be confidential, and sometimes people might reference what was said in a custody evaluation. Is the judgment going to get? I know it's not good to do that, folks. Don't do it. But if somebody does it by mistake, is the judgment going to get rejected?
We're not going to know. Our staff isn't reviewing the custody evaluation unless they overtly say, like they're quoting it. If they identify that it's there, we'll address that issue as it comes. They should not be doing it. The vast majority, we're probably not going to know that they did it because that's something we don't compare it against. But if they did, and we caught that they were putting in language that was expressly ordered to be confidential, yes, it would be rejected. It would probably be referred to for a prove-up so the judge can address whoever wrote that in and try to submit it. And repercussions will be what they be.
Sometimes people like to use the word will in a judgment versus shall. Anybody got any comments about that? I would say definitely don't use will because it's different than shall, and shall is what you really intend. Yes, no, anybody?
That pretty much sums it up.
Yeah.
Well, and I think you don't want to spend your client's hard-earned money fighting over will or shall later on in life. So
Definitely make a shall instead of a will. What else can we add in here?
Peter, is there any difference in the procedure for getting a default judgment entered as opposed to, I know you were telling us about how everything kind of traveled through MOSC. What about default judgments? Are there any detours along the way or any other stops that haven't been mentioned?
There are actually. So if you have a default entered already, it'll follow the exact same process that I told you. If you submit it with a default, they're not tracked and they're not listed the same way that other judgments are. Because we treat it as if there's a request for entry of default and a default judgment together, we won't accept the judgment and track the judgment until there's an entered default. You haven't met the minimum requirement, which is default, to file that judgment. So there's no real tracking. The benefit is defaults submitted with default judgments. They're usually just a few days. I mean, right now, I think we're working at about 2 weeks. We'll process the default. If the default is not entered, we reject the judgment for not meeting the minimum requirement of entry of default. No review is done. If there are other errors, we apologize. We're not looking for them. If it is entered, we try to time it as best we can, but if it is entered, then it goes to a clerk to be processed immediately for review. They're doing it together. They're just trying to time it up. And our timing is off right now. That doesn't get overtime. That is actually getting processed significantly faster today. Ultimately, the timing will be within a day or so once we finish with our overtime. But that's the big difference, is the review stage will happen at a different time. And the information, if it's rejected, we don't do a full review.
So a couple of questions here from people. Do we have to have a preliminary declaration of disclosure exchanged for a status dissolution, for one? And the other is, do we have to have an IED, income and expense declaration, with every stipulated judgment, since the stipulation rate waiver says it's attached?
We'll do the second one first. So the income and expense declaration attachment, if you're checking off that it is attached and you don't attach it, we'll reject it. So yes, you don't have to file that stipulation waiver form. You don't have to make that declaration. We can get in a stipulated judgment without the INE. You just can't make the assertion that it is attached. So whatever you say you did, you have to do. That's basically the general rule. And the default, say the first one again, one more time.
I think you do have to have a preliminary declaration of declaration exchanged, even for a status judgment.
Oh, yes. PDDs are required. The INE is different.
And Judge Pellman, a question kind of bringing it full circle. I know that when I'm working on a judgment for a client, I can spend hours doing that. Are you expecting the judgments to be this detailed for the judgment assistance program?
Absolutely not. These are the basic of the basics judgments. There's nothing complicated that you will have in this program. Really, people who are used to doing judgments, you should be able to do them in like 20 minutes. None of this should be at all difficult. You're just going to use the judicial council forms. You're not going to create your own language. You are not representing these parties. Okay. Absolutely not.
Thank you. Thank you.
I'll give one last tip. With regard to judgments, you might have a judgment that says your client gets the life insurance policy that they have. But if they have a beneficiary as their soon-to-be ex-wife after that, or husband after that judgment is entered, that doesn't change the life insurance. So either follow up with a letter with your client or have a term in the judgment that makes that person no longer the beneficiary of that policy. But if you don't follow up with your client on that, somewhere down the line, you might get dragged into some litigation.
Great tip.
Anybody else got some tips before we wrap up here, or are we done? Since our time has expired. All right, with that then, everybody, thank you for listening. Hope you learned something today with all the tips that are thrown out there, and thank you for participating in the Beverly Hills Bar Association program. Have a good rest of your day.